Hi, girls. Wanted to talk to you today about the Judicial Branch. Remember, as always, if you have questions, you're taking notes as you watch this. If you have questions as you do take notes, feel free to write them down, bring them into class so that we can discuss them. Because this is a branch, the Judicial Branch. You haven't learned very much about it in the past, so I suspect you'll have lots of questions. Some basic information, just like we've done for the other branch. The job of the Judicial Branch is to interpret the laws. I in interpret, J in judicial are next to each other in the alphabet. That's going to help you remember it, just like E in executive and E in enforce, and L in legislative and M in makes. So the job of the Judicial Branch is to interpret the laws. That means to figure out what the laws and the Constitution actually mean. It seems like it should be clear, but there are frequently times where what is written in the law is not clear, or multiple laws are in conflict with each other, and we have to make decisions about how to best uphold the values of our Constitution. When you think about the Judicial Branch for the United States, federal government, we're talking about the Supreme Court of the United States. We saw that building when we were in D.C., even if it was just briefly. The Constitution actually does not say how many justices there should be on the Supreme Court. It is currently 9. It has not been 9 for all of American history. Congress could change the number of justices on the Supreme Court. It's been 9 for the last at least 100 years, probably longer than that. Notice that we call them justices. A judge who is on the Supreme Court of the United States is a justice. A judge in any other level of the federal court system, as we'll talk about, or most other courts in the United States that are state and local, we just call those people judges. But a justice is someone who sort of has a special title because they're on the Supreme Court. Let's talk about why someone would go to a federal court. And you can see a picture here of the Supreme Court building to jog your memory if you don't remember seeing it while we were in D.C. Most of the things that you think of as crimes are state crimes. Okay. Sometimes we get the false impression that, like, quote unquote serious crimes like murder go to federal court because that's serious. But federal courts only deal with federal law, and the vast majority of things that you think of as crimes are handled in state courts. Drug possession, murder, rape, robbery, assault, sort of general run-of-the-mill crime. Most of that is handled in state courts. It's a violation of state law, and if you're found guilty, you would be punished in a state prison. But federal has some very specific things that it deals with, right? So some examples would be bankruptcy. That's not a crime, but there's a process for bankruptcy, and we have this whole system of bankruptcy courts in the United States federal government, judges that handle that specifically. A bankruptcy is if a person or a company can't pay its bills, and then they divide up the assets to the people who they owe money to. If I want to challenge the constitutionality of a law, so if I think that a law that my local community has created, or a law that my state has created, or a law that the national government has created does not follow the guidelines of the Constitution, I can bring a case in federal court against the state, the city, or the national government. Obviously something like spying or treason, where I'm like committing a crime against the whole United States, that would be a federal crime. Terrorism is a federal crime. Because of the amendments we've made to our Constitution, violating someone's civil rights is a crime. So if I kill someone because of their race, or don't hire someone because of their gender, or refuse to rent an apartment to someone because of their age, those are things that are crimes, civil rights violations, and you'd go to federal court for those crimes. Crimes that are interstate, meaning between states. So bank robbery is actually a federal crime because initially, you're dealing with federal currency, and those were crimes that oftentimes went between states. Sometimes kidnapping is a federal crime because it can sort of go between the boundaries of different states. Immigration violations are federal crimes because the federal government's responsibility is to deal with immigration. So crimes that involve interstate or between state issues oftentimes go to federal cases. Anything involving the military, so anyone in the military who commits a crime would often be punished in a special military court that's part of the federal court system. So there's a whole bunch of different, and a whole bunch more than this. But I just want you to be clear that most of the things that you think of as crimes, most of the things we hear about on TV, those are state and local crimes that you go to a state or local court for. In our national government, the only court that's mentioned is in our U.S. Constitution, the only court that's mentioned is the Supreme Court. Technically, we don't need more than a Supreme Court. Those 9 justices could handle all of these issues. And these are the 9 justices on the Supreme Court right here. This justice right here is the most recent appointment by President Trump. His name is Neil Gorsuch. He was just confirmed in the spring. But the other justices are here. We currently have 3 women on the Supreme Court. This court is the first time that that's happened. 2 were appointed by President Obama, and 1 was appointed by President Clinton in the 1990s. Congress actually has the power to create a whole bunch of federal courts, any federal courts, or delete federal courts that aren't the Supreme Court. And in fact, because we're such a large country, we have an entire system of federal courts all over the country that feed cases to the Supreme Court and deal with the many, many issues that come up on a regular basis here for the federal government. So we're going to talk about these 3 steps in the federal court system. We start with the lowest level of court, which is called a federal district court. There are federal district courts all over the country. If you have a case, except in sort of extreme circumstances, the first version of your case, the first trial, would be held at a federal district court. Like I said, almost every city in the United States has a federal district court. Even some smaller places have federal district courts. This is a picture of the building in downtown Cleveland that was recently built. It's only about 15 years old. This is our federal district courthouse. It's really close to the Terminal Tower in Tower City. If you're looking at, if you're driving from the west side to the east side and crossing the river, it would be on your left. You've probably seen it, and the next time you're in downtown, you should look for it, and you'll know that that is the federal courthouse here in Washington, D.C., or here in Cleveland. Like I said, this is where your case would start. So all cases begin at the federal district court level. Now, if you watch Law & Order, you might know this, but just some quick terminology around this. In these cases, there is a plaintiff and a defendant, okay? Plaintiff looks like complaint. Complaintiff, right? A complaint is lodged by the person who has been wronged. So if I'm the victim of a crime, I'm the complaintiff. I'm the one who is the complainer, the one who's got the problem. Okay? If I'm the one suing the government because a law that they've made violates my civil rights, or a law that they make violates the Constitution, I'm the complaintiff in the case. All right? The defendant is the person defending themselves from the accusation. It could be a person. If this was a criminal case, the defendant is the person who is accused and is defending themselves from the charge of treason, or the charge of murder, or the charge of whatever. The defendant could also be the government, because if I'm suing the government because a law that they passed is a violation of my civil rights or my constitutional rights, then Ohio might be defending itself. Okay, and oftentimes in these cases, the sides represented at the court involve government entities like state or local governments. Let's pretend for a second that I lose my case at the federal district court level. I have the right to have my case heard again, especially if I can argue that something was not done correctly at the lower courts. I have the right to appeal. Appeal means to have your case heard again by a higher court. It's like a second chance to see if the other court got it right. Most cases don't get appealed. Some of it is because of cost. Some of it is because you didn't think you'd get a different outcome if you went to a higher court. But for those that are appealed, you appeal to level 2 of the court system. In this case, we call the Court of Appeals. And you can see from this map here that there are only 13 federal court of appeals in the United States of America. We don't need as many. There might be hundreds of federal courts in every town of any size. But we have federal court of appeals buildings only in 13 places around the country, 1 in each district. And if you look at the map, you can see Ohio is in the 6th district for the Court of Appeals. And what that means is that if you appealed your case from Cleveland, you would go to the Federal Court of Appeals building, which is actually in Cincinnati. Okay. This is level 2. Oftentimes your case would be heard by multiple judges, sometimes by all of the judges in that particular federal appeals court, if it's a really high-profile case. And this is sort of a second hearing with more experienced judges to see if they come to a different decision. You have the right to appeal beyond that if you don't like that decision, and that appeal would go to the top level of our federal court system, which is the Supreme Court. Okay? The Supreme Court works differently than most courts for a couple of reasons. The Supreme Court gets to decide if they want to hear your case. There are hundreds and hundreds and hundreds and hundreds, sometimes thousands of cases that get appealed to the Supreme Court every year. And the Supreme Court justices look those cases over, and frequently what they decide is like, this case is sort of boring. They don't think there's any real serious constitutional question. Maybe they think whatever the appeals court decided was the right decision. And most often they say, yeah, we're not taking the case. And if they don't want to take your case on appeal, you are done. Whatever decision the appeals court made is the final decision. In an average year, the Supreme Court decides to hear about 100 cases. It used to be more. They've kind of shrunk the size of their docket, and they only hear some of the most really important cases. But in an average year, that's how many cases the Supreme Court chooses to take. When the Supreme Court takes a case, you might think they only do 100 cases a year. That's not very much. There's 9 of them. Actually, each case is really, really complicated and has a lot of steps. All right. So the Supreme Court will decide it's taking a case, and the first step then is written arguments. The lawyers for both sides, they write very lengthy, detailed descriptions of why their side is right, referencing all kinds of laws that have been passed, previous Supreme Court decisions. They really lay out their arguments in writing in quite a bit of detail. Outside lawyers can submit what they call amicus curiae, or friend of the court briefs. So tons of people are writing, and the justices are reading all this stuff before they actually have the hearing in the court. The second step is oral arguments, and we'll listen to oral arguments from a case later on this week. Oral arguments only last usually about 60 minutes. So what will happen is the lawyers for each side are given 30 minutes. They stand up. They start to read a prepared statement. At any time, the justices can interrupt and start bombarding them with questions, because they've already read everything there is to read about the case. They don't really need to hear that prepared statement. They want to ask some pointed questions and see how the lawyers respond. So the oral arguments, we think of a lot of trials taking a really long time. Oral arguments at the Supreme Court really last at most 2 hours. And that's it. Case is over at that point. On Fridays, during weeks when there were oral arguments, the 9 justices meet in what they call a conference. The 9 of them sit around a table. This is private. We don't know really what goes on in them because we're not there. No one's taking notes. And the 9 justices amongst themselves debate and discuss, and they share information. And at that point, they vote. So it's a 9-0 decision. It's a 5-4 decision. It's a 6-3 decision. And that is where they've actually decided the case. But they don't just run out on Twitter and release that decision. It's incredibly secret. And at that point, they go into a very lengthy process, sometimes 3 months, where they write out detailed legal opinions that not only say, here's how we voted, but here's why we voted the way that we did. And they release these opinions, which can be usually tens, sometimes even hundreds of pages in length, saying, we looked at this law, we looked at this in the past. And they write these for both the winning side and the losing side. So if I'm a justice and I'm on the losing side, I'm going to say, here's why I voted the way I did, even though I lost. These opinions become an important part of history, and lawyers look at them in the future and make decisions about them. Okay? And then finally, when the opinions are done being written, they have a day where they announce the final decision and they release in writing the opinions. You can go online and read the opinions from a lot of important previous Supreme Court cases. This whole process, start to finish, probably takes at least 6 months. But it could go faster depending on what the case is and how time pressing the decision is. One last thing to talk about before we finish the video. Looking at your checks and balances chart, the Supreme Court and the judicial system's power over the executive and legislative branches is the same. They can declare actions unconstitutional. Congress can pass a law. Congress could pass a law unanimously. If the court system decides that law didn't follow the Constitution, they strike it down and the law disappears. Same thing with the executive branch. The president could be doing something. If the Supreme Court or the federal court system thinks that doesn't follow the Constitution, and they say so, then the president must stop immediately or he's in violation of the law. This is quite a bit of power. It is a power that, the only power really, that the court system has, but it's a big check to protect our constitutional rights. Let me know if you have any questions. We'll discuss this when you come to class later this week. Thank you.